CNBC TV18, embarking on a quarter century of excellence.
Well, hello and welcome to News Center. I'm Ashmit Kumar. Now, the recent passage of the new criminal bills to replace existing punishment and procedural provisions had raised concerns around implementation in the legal fraternity. Now, first up, the three new criminal acts have received President's assent on 25th of December, but are yet to be implemented. This, as the Union government has, in fact, waiting for a notification date for implementation of these bills in question now. However, Union Home Minister Amit Shah recently said that the infrastructural capabilities needed for implementation of the new bills in all union territories will be ready by December of 2024. And that's not all. Issues related to change in language of different provisions of criminal punishment and procedural norms have also started to emerge, which risk an increase in pendency of cases and challenge interpretation of set judicial precedents. Now, to take this discussion ahead, I'm now joined by Mr. Azad, former Special Director at the Intelligence Bureau, as well as Mr. Bharat, Chugh advocate. Gentlemen, thank you so much for joining us, for being a part of this discussion. Mr. Azad, let me come to you. I'll just cite a recent precedent. Section 66A of the IT Act was struck down by the Supreme Court in 2015. Yet, we've seen dozens of FIRs which have invoked Section 66A of the IT Act. The most recent of them, I think, in September of 2023, with respect to the violence that we saw in Manipur. The question that I'm raising here is, for a decision to be made in New Delhi and for that decision to translate down into actual actions at the police station level, does that call for some degree of perhaps time for making this migration, some degree of training to facilitate this change? We're seeing a wholesale change. Simple decisions like striking down provisions have taken, in this case, 8 years to translate into action at the police station level. What is required for an entirely new criminal law framework?
Well, I think it's a huge transformation. And my lawyer friend would agree with me that, already there are 4.5 crores of cases pending in the court. Now, the cases which will be instituted now after the act is brought into play, notified. You see, the issue is that there are so many things. We have talked about introduction of, scientific aids. We have talked about giving a real boost to the forensic aid So all this will have to be brought in at the cutting edge level. And you're right that, the penal law reforms, for example, even in Nyaya Sanhita, about sedition cases, in May, the Supreme Court said that we should not, be instituting sedition cases. But Section 150 has been introduced where anything threatening sovereignty or unity or integrity is going to be registered as a crime. So what does one do? I mean, the training of the officers has to be there, first of all, not to institute cases needlessly under sedition. Maybe to try and give higher punishment, you try to lodge in very, very serious cases. But you're right, this transformation will not only take time, it will take energy, it will take skills, and then it has been taken from the various districts. Then the other thing is there is a mechanism here, the Bureau of Police Research and Development. Should you do it through that? So there are a lot of things to be thought about, and I'm sure that they will be thinking along these lines.
Valid point, Mr. Azad. Let me take that across to Mr. Chugh, who's also joining us. Mr. Chugh, thank you so much for being a part of this conversation. First issue, there were reports of a Delhi police officer being confronted by a magistrate as to why the new case was not registered under the BNS and why registered under the IPC. Clearly, there's a big gap in terms of decision-making in the parliament and then the action on the ground. What is this timeline that we should look at? The Home Minister is targeting December 2024 for union territories. The states are still to get back as far as their timelines are concerned. So when you look at large states such as Uttar Pradesh, Madhya Pradesh, what is a good timeline for making this transition to a new framework?
Ashwin, I think the perspective or the bulk of what we are dealing with is very, very important here. So all of these three laws, the Indian Penal Code, the CrPC and the Evidence Act, were put together more than 1,000 sections. So we are dealing with more than 1,000 sections, and some of them have subsections. So there is a considerable body of law that we are dealing with here. And these have not been just mere amendments or cosmetic changes in the sense that a few provisions have been added. There has been a complete restructuring and reorganization of the scheme and the sequence of sections. For instance, something which was a 302 IPC earlier, which we know as murder, is 101 now, or a completely different section. And I believe that given the bulk of what we have, and given the fact that there is also a lot of inertia and there would always be change resistance in the stakeholders, it would take a substantial period of time. And I must also put on record the fact that it's not just judges that we are dealing with here. The people who would have to be educated on this are judicial officers, and these are judicial officers across the spectrum, right from the nearest magistrate to the higher courts. Everyone would have to be re-educated on these laws. We have investigating officers right from the sub-inspector in the police station near you, right till the superintendent of police and the IG of police. We have prosecutors that we have to train now. Defense counsels would have to come up to speed very quickly. We have legal aid lawyers who fight cases for people who do not have a legal representation and do not have means. Those lawyers would have to be educated in the hinterland, and the situation in metros would be a lot better, but we'll have to take it to the last persons. We have other decision makers, IPS officers, IAS officers who are sitting as decision makers under various laws as executive magistrates. They'll have to be educated. The court staff would have to be educated. People would have to be educated. The prison authorities have to be educated. And just to sum it up, we cannot throw all these stakeholders at the deep end of the pool by just letting them grapple with the law. I think we should easily look at a period of at least 1 year where different training programs are organized, and training programs not just of lawyers and judges and investigative officers in silos.
Sure.
I think all of them would have to be gotten together and trained together for something like this.
So at least a 12-year window is what Mr. Chugh is telling us. And Mr. Chugh, we were following some of the comments that you made online as well, and you made some interesting comments on interpretational issues regarding the BNS as well. Mr. Azad, let me come to you. One of the issues that Mr. Chugh had highlighted was with respect to police custody versus judicial custody. The norm currently is 15 days of PC, and then after that is exhausted, you can go to judicial custody. Now, under the BNS, it's 15 days of police custody in parts over the 90-day judicial custody period. The apprehension is that the lack of understanding at the enforcement level, at the law enforcement level, could lead to a situation where, due to actions of the police or the magistrate, bail is denied even after the person transitions to judicial custody, on fears that perhaps the police may invite the candidate back for police custody. Are these valid fears that there could be interpretational issues on the ground in terms of implementation?
Yes, there are definitely interpretational issues. There's no doubt about it. And I agree with this point. But the essence of the idea is correct, because once you take a police custody and thereafter goes to the judicial custody, and you have there's another accused who's brought in, and then you want to cross both the persons, and then you need a police custody. In that case, the police custody is required, as long as the overall permissible period is the same. But how you interpret it is very important. One good point I agree with the previous speaker is that, during the training, that is why these judicial officers, prosecutors, and the investigators should be brought together. And then they should be, addressed by the police officers, the judicial officers, and other people, so that a lot of questions which come in during the actual field trials or the field practice would be brought to the fore. And that's a very important thing. Another point which you asked earlier, I would say that in places in UP, Madhya Pradesh, very large states, I think it will still need 1.5 years minimum. I have been from Madhya Pradesh cadre, and I realized it is extremely difficult to go in very deep in the rural areas and make them understand, because life is totally different from a metropolis to the sub-towns to the rural areas, where far-flung police stations cover about 80 to 90 villages.
Right, Mr. Chugh. Right, Mr. Azad. Right, Mr. Chugh. Thank you so much for the time that you shared with us. We're running out of time. I'll have to cut short this discussion, but thank you so much for this perspective that you've given us, that we do need a fair amount of training of the entire legal framework, whether it's judges, lawyers, or police personnel, and that there is a 12 to 18-month window that may be required for making a smooth transition from the current IPC CrPC regime to the new BNS framework, which has been introduced and notified on December 25th. With that, we're heading into a very short break, but on the other side, we bring forth the discussion on the Telecom Act and what it entails in terms of privacy versus interception rights of the government. We'll get you more on that on the other side.
CNBC-TV18, embarking on a quarter century of excellence.